Swayam Prabha. Digital India. Educated India.
Welcome back to the Law of Torts, Consumer Protection and Motor Vehicles course. This is the 11th lecture, and in this lecture we will discuss the tort of trespass to person and false imprisonment. Now, trespass is a very old and classic tort. Trespass can be awarded for very many purposes. Trespass can be against person's body, trespass can be against person's property, trespass can be against person's land, trespass can be against person's goods, trespass can be against person's chattels. So, trespass can be for very many purposes. Trespass would ideally mean a unwanted or a uninvited invasion into somebody's body or somebody's property. Now, in course of this lecture, we will discuss these following important topics. First, trespass and its types. So, as I said, trespass can be, in overhead, trespass means any kind of, invasion into somebody's bodily space or property without his consent or without his knowledge or without his approval. So, therefore, trespass can be of various types. Trespass can be relating to body, trespass can be relating to immovable property, land, house. Trespass can be with reference to movable property like goods, books, any other thing, and trespass can also be in connection to other types of chattels. Now, therefore, these different types of trespass we will discuss. Then in this particular lecture, we will focus only one category of trespass, and that is trespass to person. Now, trespass to person ideally is committed by either an assault or an battery. So, there are two types of ways in which trespass to person can be committed. So, what are the distinction between this assault and battery? Sorry, please forgive me, there is a small spelling error. It is DISTINCTION, distinctions. What are the distinctions between assault and battery? Lastly, we will discuss another category of tort which is not trespass, but which has close connection to it, which is tort of false imprisonment. So, that is why the topic is called the trespass to person and tort of false imprisonment. So, these are the four topics that we are going to discuss in this course of this lecture. So, we start with a very fundamental question that what is trespass? Now, I will give you a interesting problem, okay, and let us try to see that can we consider this as a trespass. Say A is a company which is doing business in emails. So, it is a email server company, a company which provides email service. Now, for the purpose of providing email service, what A has done is that A has a server. A have purchased server or server space. However, the server or the server space, whatever he has purchased, it has certain limitations. So, nothing is unlimited. Whenever you buy anything, it has some limit. So, 15 GB, 1 GB, 1 terabyte, whatever. But limit is there. Nothing is unlimited. So, this email service provider server also has limited space. Now, it has allowed its all the service takers some space in its larger server. Now, judicious use of this space means that you keep your important emails. So, the emails which are important you keep this, and you do not intend to also receive what we call junk mails. Not receive what we call junk emails. Now, unfortunately, if we continue to receive junk emails, now what this junk email does and why it is problematic? Because junk emails eat up this server space. So, this server space is already limited, and that limit should be judiciously used for the purpose of ensuring that the important emails that we are receiving, the business communications are kept there, all the users. However, if continuously people are receiving these junk emails, so junk emails eat up the server space, and because of this junk email now eating up the server space and limiting it further, the actual space provided for the purpose of the important emails gets reduced. Sometimes it gets bounced, sometimes it says no space, sometimes you have to delete some of your important emails because you do not have space. So, is this sending of junk email some kind of a wrong? And if it is a kind of a civil wrong, some kind of a civil wrong, and if it is a civil wrong, what is the kind? What is its kind? What kind? So, if we say these are the two questions. Now, answering the first question, yes, of course, because this is an invasion. The courts have held that sending junk email is an invasion or intruding into my personal or my public space, my private space without my approval. And therefore, if it is an invasion or intrusion into my private space, because this space that I have is my private space, the email space, this is my private space. So, any junk email sending into this space is an intrusion into my private space without my approval, and this attracts what is called trespass to chattel. The wrong of trespass to chattels. So, you can realize therefore, any kind of invasion into anybody's personal space is without approval a trespass. Now, if it happens to the bodily part, then it is trespass to person. If it is with immovable property, then trespass to land or trespass to property. If it is movable property, then trespass to goods. If it is this kind of chattels like space in the internet or other ways, then it is trespass to chattel. right? And so trespass can be of varieties, trespass to animals can happen. So there are varieties of ways trespass can be there. We are going to discuss only few of them. So what law defines trespass is that tort of trespass can be committed only by direct invasion. So a direct invasion, so what are the elements of trespass? A direct invasion, 1, 2, by a positive act. A direct invasion by a positive act which is actionable, subject to justification. So any trespass will be a 1, a direct invasion, B, by a positive act, and which is actionable. Okay, without justification. So these are the three very important connecting factor for any types of trespass: direct invasion, positive act, and actionable per se, actionable subject to justification, right. Now the question is, what cannot be trespass? Now the example that I gave, now this is an example where law and technology meet. Now this became the whole question of junk mail, and junk mail problem became a problem when we had this internet technology evolving and email became a most important form of communication, and all these abuses of the ICT system also started. Now with the advancement of technology, problems when come, law has to give solution, and in our haste or in our desire to quickly give a solution, the solution that we gave in this case was that it is a trespass to chattel. Now it is not wrong, but the only problem is that if this is a trespass to chattel, because it is an electronic space consisting of what you say waves and all. Similarly, therefore, a television screen also becomes a similar kind of a space. So any kind of things that we see in the television we don't like in between India-Pakistan cricket match at the 40th over, Sachin Tendulkar batting and Wasim Akram bowling, we don't want to see advertisements, but it happens. So it's an intrusion. Okay. So therefore, a lot of things can come. So many people say that this was not a very good derivative way to consider this act as a trespass to chattel, and the law of IT has subsequently changed the position also. This is a very earlier deduction, but it shows that how we are trying to connect trespass law to even more extended aspects, right? How tort law we are trying to connect to extended aspects. Now when we say what is trespass, we say these three things: direct invasion, positive act, and actionable, some wrong has been committed. But what is not trespass? Therefore, obviously, just negative of this, where invasion was not direct though foreseeable, or if the invasion was from an omission as distinguished from a positive act, there could be no liability in trespass. For example, I have removed one manhole in a road which usually is dark at night. So of course somebody will fall if somebody is walking, because they will not be able to make out that there is a manhole there or manhole not there in the dark night. Now that will, when somebody pass, cause injury, but will that amount to trespass? No. Why? Because this is not a direct invasion. Trespass has to be a direct invasion. This can be other forms of torts, but this will not be a trespass because this is not a direct invasion. Similarly, this omission to do something is not also a trespass. I know that he was trying to sit and he thought that I will place a chair behind him or I will hold him from behind. So, he was trying to fall back and I was supposed to standing behind hold him, but I did not, and it was not intentionally. I did not realize that I was supposed to act in that manner. Now, in that case, that is an omission, but that also commits some kind of a injury to him, but that is not to be regarded to trespass. There can be some other law of torts wrong if possible to be deducted, but not trespass. So, trespass cannot be when the invasion is not direct or the invasion is form of an omission, although it was quite foreseeable that this could have happened. Removing a manual, it was foreseeable that somebody will fall, but because there was no direct invasion, it cannot be accounted for trespass. Similarly, if the invasion is unintended, though direct and resulting from a positive act, there will still be no liability if the conduct of the defendant was reasonable, and even it was unreasonable if the invasion was an unforeseen consequence. So, what does this mean? Invasion is unintended. Okay. Now, I thought a person who was walking in front of me, my friend, a very old friend. So, what I did was I went and I hugged that person, and then after hugging I realized that he is not the person I was thinking. He looks almost similar, but he is not that person. Now, can this be a trespass? Because it is a direct act and an actionable and a direct invasion and a positive act? No, because it was unintended. It was not intended to be in that way, right? Or invasion was unforeseeable consequences, okay? Or something that happened was an unforeseeable consequence of some act. Okay, it was an unforeseeable consequence. It was not something which was foreseen that this will happen, right? So, I was cutting tree, I took care, and some of the bushes were down left, and I did not saw that a car will pass, but a car passed, and there was a puncture, and that is a trespass, trespass to goods. Okay. Now, but that will not be justified because it was an unforeseeable consequence, because that road no car usually pass, but that day a car unfortunately passed. So, unforeseeable consequences. So, for unforeseeable consequences also there is no case for trespass. Now, when trespass action succeed, when trespass action do not succeed, there are two leading cases of the English courts which discusses. So, let me just read and quote from those judgments. First is Flower versus Ranning, 1959 decision by Queen's Bench. Here the plaintiff claimed damages from trespass to the person, and so the trespass in question is trespass to the person, and the plaintiff claimed damages, and a statement of claim alleged laconically, not very categorically, not very specifically, not very pinpointedly, but in a very laconically, that the defendant shot the plaintiff on a particular date at a particular place. So, the defendant shot the plaintiff on a particular date in a particular place. Now, court held that trespass to person does not lie in if the injury to the plaintiff, although direct consequence of the act of the defendant, was caused unintentionally or without negligence on his part. Now, he shot a gun fire to shoot a pigeon, but unfortunately the the hit missed, and the plaintiff standing some distance away hit him. Now, in that case there was no intention, but of course it was a direct consequence. He shot, he missed the pigeon and the bullet hurt that person, but it was unintentional, A, and it was not something like with somebody a bullet, a person planning to murder, right. it's a toy gun bullet, plastic bullets of toy gun, which is good enough to shoot a pigeon. So he shot that plastic bullet, but it can be causing a lot of pain if it hits in a particular. It may enter your body, prick inside your skin, or cause some other injuries also. Unfortunately, if it hits your eye and all, you may even get blind. So in this case, he said that he shot, but it was a laconical statement, although the date and place particulars were provided. So the court held that trespass to person does not lie if the injury to the plaintiff, although the direct consequence of the act of the defendant was caused unintentionally and without negligence on his part. There was no negligence. The plaintiff suddenly came. It is not that the plaintiff was standing there. Second is, in Letang versus Cooper 1964, the Court of Appeals held the plaintiff, while taking sunbathing, was run over by a car driven negligently by the defendant, causing injury to her legs. So plaintiff was sitting in her lawn and taking sunbath. The neighbor of the plaintiff was driving a vehicle in a negligent manner, and in that process the defendant caused injury to the legs of the plaintiff. More than 3 years after this incident happened, the plaintiff brought an action against the defendant for damages for loss and injury caused by A. negligence, B. trespass to person. So you can see now it is not unusual to plead more than one tort in a same action, because you never know which theory may not apply. So more than one tort is common. So therefore in this case the plaintiff pleaded for negligence and trespass. Now the application of tort of negligence was ruled out straightforward, because the case was filed after the expiry of the limitation period. So every case or every cause of action has a limitation. Nothing is unlimited. You cannot say that you have the right to sue against a person in unlimited fashion. Everything has a limitation. So there is a limitation act. So the limitation act prescribes that a cause of action for negligence is to be brought within the period of 2 years or 2.5 years or even 3 years. And the plaintiff had filed this suit after 3 years, and which was outside the period prescribed for limitation. Now the question was, sir, therefore negligence action did not sustained, because it was outside the case of outside the period of limitation. So therefore a tort of negligence was automatically discharged by bar of limitation. When we discuss dischargement of tort, we will see one of the grounds for dischargement of tort is limitation period. That limitation period is over. So the tort is discharged. So negligence was discharged, where actually the defendant was wrong, because he was negligently driving. But the second was trespass, because of course there was an invasion to his limb, which is bodily part, which was a positive act and it was actionable. Now the question here was that whether the action of trespass will succeed. Court held that when the injury is not inflicted intentionally but negligently, the only cause of action is negligence and not trespass. So the court says that in case of trespass, intention is required. So trespass has some element of intention. There has to be an intention. So trespass can be considered as an intentional tort. So there are some torts where, as I said, generally torts does not require intention. But there are some torts where intention is required. Trespass is one such tort where intention becomes a factor. Without appropriate intention, simple negligence is not enough to prove a case for trespass. So in this case the court said that yes, the defendant had inflicted the injury negligently. If it was a suit for negligence, we would have probably also granted compensation, but the suit for negligence is barred for limitation. Now in trespass, we cannot grant compensation based on negligent act, because we require an intentional act, and in this case there was no intention. So therefore lack of intention makes this case not actionable in trespass. So unintended invasions have been completely eclipsed by the tort of negligence. that survive now under trespass are only intended invasions. So, therefore, if there are any unintended invasions, that as the only way to pay or to file is negligence. Trespass to person is only related to unintended invasions, or trespass to property, or trespass to body, trespass to goods, only intended invasions. So, trespass therefore becomes a tort which is intentional tort. Now, coming to trespass to person. Now, as I said that there are two types of trespass, two types of ways in which trespass to person can happen. What are these? One is called assault and the other one is called battery. Now, what is assault and what is battery and what is distinction? That is something we will now discuss. Now, what is assault? Assault is an attempt or a threat to do a corporal hurt to another, coupled with an apparent present ability and intention to do the act. Actual contact is not necessary in the assault. अब कोई भी 1980s का हिंदी मूवी ले लीजिए, any हिंदी movie of 1980s. The plot was same. गांव के गरीब लड़का, अमीर जमींदार का बेटी, दोनों में there is love, and that love takes them to the question of marriage, and then that Amir Jamindar family denies to give because the house to the house of a poor family of the boy. The boy's mother go pray, and the Jamindar or his family members insult, sometimes hit, and then the hero comes back and in a very aggressive manner, with or without an arm, stands in front of the villain and says, "Kutte kamine main tera khoon pee jaunga." This is assault. When you stand in front of somebody with your fist like this and say, "Kutta kamina main tera khoon pee jaunga," and you aggressively move towards him, that is assault. There is no need to touch. Aggressively behaving with behavior, moving towards is enough to constitute the tort of assault. So, what are the components therefore? A threat to do a corporal hurt. Kutta kamine main tera khoon pee jaunga. Khoon pee jaunga means corporal hurt. Khoon pee jaunga. Kutta kamina main tera khoon pee jaunga. How is this word said and what is the bodily language of that person? Aggressive face, red eyes, okay, with a fist like this, with a very steep body, charging manner. It is almost like a charging bull, and saying "Kutta kamina main tumhara khoon pee jaunga." And what is this? This is assault, because actual contact is not necessary. आप खून पिया या नहीं पिया, you hit that person or not hit person, that person not necessary. That is assault. So, example that has been provided in the slide is, A laid his hand on a sword and said to J, "If it was not assize time, I would not take such language from you." This was held whether an assault or not an assault, the statement. So, basically what this means is that two persons are standing face to face, one has said something, the other person is having a sword on his kamarband or attached to his waist. He touches that sword, okay, he touches the that handle of the sword, he holds it and says, "If it was not the time of siege," siege means ceasefire, there was no fight to take place at this time, "it was not the time of siege, I would have not taken this word from you." So, What does this mean? That means that because the time of siege he will not do anything. So there is of course nothing to fear about. If he said that, I would have not taken your word, etc., only, then it would have been different. But here he says, of course in an aggressive manner with all his body language, touching the sword, but what is important is what? If it were not a siege time. So because it is a siege time, now there is no question of that person entering into any sort of physical violence. So therefore, if this word has been said, then that saves the person from an assault. So it was held not to be assault on the ground that the word showed that A did not intended then and there to offer violence to J. Because it says that at this time of siege, other than this time of siege, I would have not taken this, but at this time of siege, I am taking it. Although I have my sword, but I still respect the ceasefire. So there is no assault, right? Similarly, agar you are holding a pistol and pointing it to someone and say, I will kill myself if you don't come to me, I will kill myself if you don't come to me. Now will that amount to assault? No. Because he is not saying that I will kill you, he is saying I am kill myself. Now you can say it's it's kind of he is coercing. Yes, coercion is there, but not all coercive forces would render to assault. Now comes the second type of trespass to person, which is battery. What is battery? What is assault we understood? Now what is battery? A battery is an intentional and direct application of a physical force to the person of another. It is actual striking of another person or touching him in a rude, angry, revengeful or insolent manner. So somebody is standing there, that same 1980 Hindi film hero. What is doing? Kutta kamine main tera khoon pee jaunga. What is happening? Assault. But the moment he touch, ek bar touch ho gaya, it is not assault, it is battery. So all the quality of assault followed with a touch becomes a battery. If the qualities of assault are not there, the touch cannot make it a battery. So to make a battery, all the qualities of assault has to be there and the touch has to be in addition. So that's why there is a saying that all batteries are assault, but all assaults are not batteries. In every case, this is a I always use this chemistry formula. All alkalis are bases, but all bases are not alkalis. When I try to discuss this kind of similar relationship. So every case of battery and assault comes within the similar kind of relationship. So every case of battery will have an assault, but every case of assault did not require to have a battery. So battery is assault plus touch. So all elements of assault plus touch. So what is battery? Battery is an intentional and direct application of any physical force to the person of another. It is actually striking of another person or touching him in a rude, angry, revengeful and insolent manner. Somebody is standing beside me. I went, "Hi, how are you?" Is it a battery? But I touched him. But there was no rude, anger, revengeful, insolent manner. But when I aggressively say, "Kutta kabira main tera khoon pee jaunga," and I go and touch him or slap him, that's battery. So just the touch does not make it a battery. What is required is this rude, angry, revengeful, insolent manner which makes an display assault. Assault plus touch, then only it is a battery. Now there are some cases which we will discuss to understand this better. Now, in this case Stephens versus Mayers in 1830, what happened was that plaintiff was the chairman. The facts of the case is the plaintiff was the chairman of a PASH meeting. The defendant having been very vociferous, a motion was made and carried by large majority that he should be turned out. Upon this, the defendant said he would rather pull the chairman out of the chair than be turned out of the room, and immediately advanced with his fist clenched towards him. He was thereupon stopped by the church warden, who sat next but one to the chairman, at a time when he was not near enough for any blow. He might have mediated to reach the plaintiff, but the witnesses said that it seemed to them that he was advancing with the intention to strike the chairman. So, what happened in this case is that in a board meeting there was one person who was very anti the chairman and he was voicing his protest. Now, the other members was not liking because it was disturbing the meeting. So, take a motion by majority that this person should be asked to leave the room or go out. Now, when this motion was passed, he said that before anybody asks me to leave or make me to force me to leave this room, I will take the chairman out of that chair and I will throw him out of this room. And after saying this, he stood up and with a clenching fist, he approached the chair. Now, before he could reach actually the chair and there was substantial distance, a church warden caught him or resisted him. Now, the distance that was there between him and the chairman was not enough for him to hit the chairman, unless he was trying to mitigate that by force. But the people who were there in that room, the witnesses, they said yes, we were very scared because the way he advanced, it was clear that he has the intention to strike the chairman. Now, in the case of an assault or battery, in this case, the court held a case of assault, not battery. Touch, there was no touch, so there is no question of battery. That this is a case of assault. Court held it is not every threat when there is no actual personal violence that constitutes an assault. There must in all cases be a means of carrying the threat into effect. The question I shall leave to you will be whether the defendant was advancing at the time in a threatening attitude to strike the chairman, so that his blow would almost immediately have reached the chairman. If he had not been stopped, then though he was not near enough at the time of have struck him, yet he was advancing with that intent. I think it amounts to an assault in law. If he weren't so advancing that within a second or two he would have reached the plaintiff, and it seems to me it is an assault in law. So, the court said that it is not that every threat need to be actually considered as assault. I threat, I will, you are talking like this, you do not know me, I will see you. Now, that may not be an assault. Assault has to be something where there is a threat in my language, there is aggression in my body, there is followed by sufficient bodily conduct which creates a threat in the mind of that person, that there is a possibility of an actual personal violence that will constitute an assault. The other side or the people who are around there. So, agar, in a very polite and humble manner, I say, okay, you are doing like this, don't worry, I will see you. Now, this can have other implications, but this will not have, in actually if really something happen, this statement can have other implications in law, but this will not be definitely a statement which will book me for assault. But if instead I say, you do not know what I can do with you, I will, and I can see in your eyes the fear, and now you will see what I will do for you. I will now hit you and throw you out of this room, and then with this kind of a fist and body expression, I start running towards him. This is what is called the actual personal violence which is associated with my statement, and that statement makes it an assault. And whether in this case the court asked such a scenario was presented, and the court said the accounts of the witnesses who were present in that room at that point of time displayed quite similar to that. What was the account of the witnesses? The accounts of the witnesses was that he was disturbing, he was aggressively behaving towards the chairman from the beginning, and when this motion was taken, it displeasured him more, and especially when the motion was that he should be now turned out of the room, that is, he should be removed from the room, it made him mad. And in that spurt of madness and anger, he started saying that I will, before being removed from the room, take the chairman away out of his chair and throw him out of the room. And with this statement, he with a fist started approaching the chairman. This is enough to create an impression among the people, including the chairman, that this person is actually progressing for a personal, with a personal violence, actual personal violence. He is not just saying something which does not have a meaning, like the earlier statement, holding the sword, if this was not the time of cease, or you don't know what I can do, I will see you. Now these are statements which will not create any kind of an appearance of physical violence. But when somebody says that before you turn me out of this room, I will pick him off out of his chair and throw him out of the room, and then with a clinching fist approaches toward that person, that gives an impression that yes, what he is saying he can do. And what he can do? He can commit a physical violence. There is a possibility, and the possibility is not remote. In the next case, again the same question, that whether the act of the defendant amounted to assault. Now what happened in this case was that a person had taken some loan from a money lender and he was unable to repay, or he has not repaid, whether unable or he did not, but important issue is he did not repay. Now in the middle of the village, that money lender or the munsip threatened to distrain the earrings which the plaintiff was wearing for recovery of land revenue. So the munsip or the money lender said that I will distrain your earrings. So he was wearing some gold earrings. He said I will distrain your earrings which the plaintiff was wearing for recovery of the land revenue. I will distrain and I will sell and I will recover your land revenue. And the village goldsmith was called, on which some paid the land revenue on behalf of the plaintiff, and the defendant left quietly. Now when he was saying this, after that he sent the village goldsmith, because the village goldsmith can come and now break that and he can then distrain it. But meanwhile, when the goldsmith was called, some other person of the village paid the land revenue on his behalf, and once the land revenue was paid, the defendant made no fuss and left quietly. Even when the defendant was passing, the village goldsmith had arrived and he said nothing. The question was that his first statement, that I will distrain your earrings which for the recovery of land revenue, whether amount to an assault. Now if we go by the elements of assault, as we have seen in the earlier case, the elements of assault is that a threat to do a corporal hurt. Yes, it is satisfied. I will distrain your earrings, a threat to do a corporal hurt, coupled with apparent present ability and intention. He had an ability because he called the goldsmith, and intention was there, but ability, coupled with that ability, But what is missing here is that actual striking of another person. Sorry, what was missing here is this rude, angry, revengeful, insolent manners of behavior. So, ability he did not, whether he had or not, that is not important to measure in that way. What is important is that he could have snatched it also. But did he show that aggression? He called the goldsmith, but the moment he got the money, he was living simply. So, therefore, his intention whether was there or his ability, or it was just a threat that he was giving to make him scare or make sure that by this way somebody else will pay. So, that was his actual intention, and that is why whether it was an assault or not, the court held that it was held that it could not be said that the plaintiff was put in fear of immediate or instant violence. So, therefore, in both the cases, one important aspect that comes in an assault case, fear of, to ensure that to see that whether this case falls within the criteria of assault or not, this is important. Sorry, this is important, fear of immediate or instant violence. So, fear of immediate or instant violence and a threat is essential for assault. So, therefore, for assault, if we say assault, what are the essentials? 1, threat to do a corporal harm. Threat to do a corporeal harm with a fear, accompanied with a fear of immediate or instant violence. So, just a threat of corporate harm is not an assault. When a corporate harm is associated with a fear of immediate or instant violence, then only it is assault. And when this assault becomes battery, when this two is added with touch. You are saying, I will split on you, dog, but till you spit, it is assault. But the moment you split, even till then it is also assault, because the split may not touch the person, it may fall by side or fall on another. But if the split falls on that person, it becomes battery. So, I will split on you, and followed by the fear or immediate instant with the physical, I will split on you, dog, bloody dog, and then you split. Even when the split is on air, it is still assault, but the moment the split falls on the body of the intended person or the plaintiff, it becomes a battery. So, in Jai Bhagavan vs Suman Devi case, this distinction was asked that when and how assault, battery are different. So, the court said that battery includes an assault which briefly started in a overt act evidencing an immediate intention to commit a battery. It is mainly distinguishable from an assault in a fact that the physical contact is necessary to accomplish it. It cannot mean merely an injury inflicted by an instrument held in hand, but includes all cases where a party is struck by a missile thrown by another. It does not matter whether the force is applicable directly to the human body itself or to anything coming in contact with it. In order to establish the tort of battery, the plaintiff must however prove that the force used was without lawful justification and without lawful justification. So, example, throwing water at a person is assault. If any drop falls on him, is a battery. So, split up till the point the split is in the air, it is assault. The moment the split falls on the body, it is battery. The fact that the wrongdoer has been fined by a criminal court for assault is no bar to civil action against him for damages, right. So, assault can also have criminal component. IPC also says criminal force, assault. So, if a person has been already fined or has been imprisoned for a criminal action in assault, there is no bar that a civil action cannot be also filed. So, a civil action can be also parallelly pleaded for a assault or a battery case. Now, we move to the third component, last component of this lecture, which is tort of false imprisonment. Now, we are dealing with the category of torts which are affecting human body, human liberty, human dignity. Of course, dignity will also include privacy and all, but we are saying human body and human liberty, right. So, physical assault is trespass to person is a matter of physical assault, either by itself or by force or by physical assault, by split, by water, by any agent, right. Now, false imprisonment is a kind of a tort where a person is restrained in a place, his liberty is restrained. So, false imprisonment is a total restrainment, that is very important. There cannot be a partial restrainment, total restrainment of the liberty of the person. So, false imprisonment is a total restrainment of the liberty of a person for a short time without a lawful excuse. Okay? So, it is a restrainment of the liberty of a person for a short time without a lawful excuse. It is a tort of strict liability and the plaintiff has no proof not to prove fault on the part of the defendant. So, if you even without intention stop somebody or restrain somebody from the liberty of the person, it is not to be proved that it was intentional or it was negligent or something, even a normal act, because it is a tort of strict liability. So, no fault kind of. Then what constitutes this wrong? Total restrainment of the liberty of a person, that is important, and the detention may be either actual or constructive. So, either actual detention can be there, not actual, it is actual. So, either actual or constructive. Constructive is through other. You are detaining someone through other person. The detention must be unlawful. So, there should not be a lawful detention, it should be unlawful detention, and detention continues in an unlawful manner. So, the court had an opportunity to consider that can a person be detained in a in a open space. So, it is not necessarily that he is detained in a room or in a facility, in an open space. So, in this case Bart versus Jones, a person who was walking in the bridge which was partially blocked for the purpose of using it as a spectator stand for a boat race, and he was not allowed to pass, his restraint. When he went, the question was that it was an open space, it was partially for a time, but he was restrained. He was not allowed to pass that, and there was no other passage. Whether this amounts to false imprisonment. The court held that a part of the bridge generally used as a footway was appropriated for the seats of the view of the boat race. Sorry, the court decision is: a prison may have its boundary large or narrow, visible and tangible, real. Still, in a conception, it may also itself be movable or fixed, but a boundary it must have. And that boundary the party imprisoned must be prevented from passing. He must be prevented from leaving that place, within the ambit of which party imprisoning would confine him except by prison breach. Some confusion seems to me to arise from the confounding imprisonment of the body with mere loss of freedom. It is one part of the definition of the freedom to be able to do whatsoever one pleases, but imprisonment is something more than mere loss of this power. It includes the notion to restrain within some limits defined by a will or power exterior to your own. So, any imprisonment means that when somebody is restrained from his limits to move without his will. So, and that is by the power of exterior. So that's false imprisonment. So therefore, I end this lecture here, and thank you for being part of this course and this lecture, and I hope to meet you again in the next lecture. Thank you very much.